All right. Thank you, everybody, for being here. This is a great presentation that we have next. If you work in the housing industry, you have to take this class, especially if you want to deal with tenants and you've been doing in this field for even long time. It's always a good refresher to learn about these laws. So thank you again. And for the next workshop, we have our local celebrity, Martha Mothershead.
So
She
lovely.
gives a good workshop at the adult education, and she's going to be talking to us about this workshop, the small landlord seminar, Know the Law. So, having said that, welcome, Miss Martha Mothershead. Take it away. The field
Thank
is
you,
all yours.
Jorge, and welcome everyone. Just so you know, I can't see you. I can only see my screen. And you're going to have to ask questions by typing them into the chat bar. So you can't just wave your virtual hand and ask me a question, but I'll stop periodically. I think I'll stop at 1 hour and then I'll stop before the end to give a couple of question and answer sessions. But my name is Martha Mothershead. I'm a landlord tenant attorney, and I also do other areas of law. I have been with Baskin, Jackson, and Lasso since about 2011, and we're in Falls Church City. This is what our office looks like. It's basically an old house across from City Hall in Falls Church, and Arlington is our jurisdiction for courts. Just introducing you, this is my family. I've got a son, a daughter, a husband, and a dog who comes to work with me a lot. So if you ever come here, you might meet him. Um, so my practice is basically anything to do with leases, including evictions, negotiating the leases, lease violations, and mostly I represent landlords. I very rarely represent tenants, and part of that is just the economics that tenants often, when they have problems, can't afford an attorney, and they have to usually go to legal aid. But I also do estate planning, so that's wills, trusts, probate, guardianship, and conservatorships. And I teach both classes, one on landlord tenant law and one on estate planning through Arlington Community Education. Usually both classes each quarter, depending on how many people enroll. So this class is about landlording, just residential landlording. So I'm not going to talk about being a commercial landlord at all. And this is really for the homeowner who's thinking about being a landlord or who already is a landlord, just so that you know you're not in danger of violating the law, because the law has really changed a lot. It's changed a lot just this year under COVID, and it's changed an awful lot since 2019. So we used to have two bodies of law that governed residential leases in Virginia: the Virginia Residential Landlord and Tenant Act, and we're going to call that VRLTA from now on because it's just too long to keep saying that, and the Virginia Common Law. So what common law is, it's just the history of case law that's built up over the past couple hundred years. And whenever a published opinion was issued by a judge, usually a Supreme Court judge or a Court of Appeals judge, that would become precedent that we had to that we lawyers have to follow, and you folks have to follow too if you ever get into litigation. And then a lot of that law got changed into statutory law, and that was under Virginia Code 55-225. But now that whole section has been repealed and everything falls under the VRLTA. And the reason I'm talking about this, you don't need to write down any notes about common law. I just want you to have an overall framework in your head. Because the reason I'm talking about both sets of law is there's still a lot of common law leases out there. So if you're a landlord and you're looking for a lease online, or maybe you have a friend who's a realtor and they give you a lease, I want you to be sure you don't use a common law lease because they're not allowed anymore. And if you do use one, it will not be enforced to the extent you think it will be. So the differences under common law leases, just some of the main differences, is that a landlord's right to enter the property was governed just by the lease, not by law. So if you didn't have it in your lease that you as the landlord could enter the tenant's property to inspect periodically, to make repairs, you couldn't enter. So that's one thing that's been fixed. The landlords were, I think, favored under the law, under the common law, more than they are now under the VRLTA. I think things have evened up a lot, and tenants have a lot more rights, and you should be aware of those. Under the former law, and on my PowerPoint, every time I have LL, that stands for landlord, and T stands for tenant. So landlord could delegate a lot of its maintenance duties to the tenant if the contract was entered into fairly and freely and in good faith. That means that the landlord could rent a place and just pretty much wash their hands of having to do any maintenance for that residence, and that's not the case anymore. A landlord could prohibit and restrict firearms in a residence. You can't do that anymore under VRLTA. Firearms are allowed in Virginia, and so they're allowed in a residence. And a landlord could require a larger security deposit or a bond than they do now. So the limit now is 2 months of a security deposit. This is what the top of an old common law lease would look like. It would really be, you'd find it right at the top. Either it would say common law residential lease agreement, or it'd be in the first paragraph. And it would say this lease is governed by the common law of Virginia, and the tenancy is exempt from the VRLTA. Now you want a lease that says this lease is subject to the VRLTA. So don't use the common law leases anymore. And I think that's about all I need to say about that. The new law went into effect in 2019, and it applies to all single family and multifamily dwelling units. So that means a place that somebody uses as their home. This class is not about commercial properties, business offices, that kind of thing. It's just about dwelling units. The VRLTA does not apply to nursing homes and hospitals, jails, other types of places where people live, like frat houses, campgrounds, religious homes, hotels and motels. It doesn't apply to transient boarding houses unless it's a place where the occupant has been living there for more than 90 days. So that sometimes will bring in places like an extended stay America or a residence inn if the tenant is using it for more than 90 days. I've never had any of those hotel type facilities as my clients, so I don't know how often that applies, and I don't know whether they limit, as a general rule, limit people from staying more than 90 days. But as a general rule, if it's your occupants, if it's your home for more than 90 days, the VRLTA is going to apply. Some more of the changes in the law that are helpful to both sides, in my opinion, is that a lease can now state that notices, so this would be something like they haven't paid their rent on time, or they're smoking in a non-smoking property, or they're not taking their trash and disposing it in proper places. All of these would be incidents where a landlord would want to send a notice to a tenant saying you're breaching the lease, and those notices used to be required that they had to be sent in paper form. And so that usually would mean mail or personal delivery, or sometimes delivery by a sheriff. Sometimes it meant certified mail. Now the lease can state that notices will be sent electronically. So that means basically email. I don't think you should ever rely on texts for sending notices to a tenant, and texts make pretty crummy proof if we're ever in trial, because there's just a lot of foundation issues to get a text into evidence. So if you're going to do notices only electronically, use email, and keep a hard copy of each email that shows the time and date that it was sent. And keep in mind too that under the law, a tenant can request that the notices be made in paper. So you may have a tenant that just wants an old-fashioned written notice mailed or hand delivered. A lease now can provide for electronic deposit of rent. So if you don't want to take rent checks, you don't have to. You don't have to take cash. You can put in your lease that you're only going to accept payment electronically. If you're going to have an application, and I highly recommend that you do, you can charge an application fee of up to $50. And the reason why you'd want to charge an application fee is because you should be doing a credit check on anybody who applies to rent your property. And I know a lot of people that get so excited, they list the property and they get some interest and they think, oh, great, I've got income coming in now. And it's very easy to want to take those first tenants. Do run a background check that checks their credit. And that means that you're going to have them fill out an authorization. They're going to have to give you their social security number and their full legal name. And then that gives you permission to hire a company to run that credit check. And usually those cost about $50. So that's what the $50 application fee is going to cover. Like I said, you can only charge a maximum of 2 months rent as a security deposit. Most tenants don't have that. I don't know any landlords that do collect a 2 full months rent as security deposits. In fact, a lot of my clients that are the larger apartment building owners, they don't even take security deposits anymore. They have the tenant pay for an insurance policy that covers property damage and loss of damage to the tenant's contents. The landlord's not responsible for the tenant's contents in most cases. There's a few exceptions that I'm not going to get into right now, but tenants should always be required to provide proof to you that they have insured their contents. That's a renter's policy, because believe me, if there's a fire or a pipe burst or something and the tenant's property is destroyed, they're going to be turning to you and saying, hey, what are you going to do about this? You need to replace all my stuff that was ruined. And your answer is going to be, sorry, you were supposed to insure your stuff under a renter's policy. And a lot of tenants know that that's in their lease. They know they're supposed to do it. A lot of landlords think that their tenants have complied. I suggest that you always ask for proof of that insurance policy before you sign the lease and let them move in, because sometimes they will get the proof and then not actually pay for the policy and it's canceled right away. So it's a violation of most leases to not have a renter's insurance policy paid up and in place. Another thing that you should know about that's a change to the law is that a landlord cannot make a unilateral change of terms. And so that means one-sided. There can't be a one-sided change of a lease. A landlord cannot just all of a sudden say, I'm going to raise the rent. The tenant would have to agree to that. And where that comes up is not in the middle of a lease term. It usually comes up at renewals. So if your lease says that it automatically renews at the end of a year, unless one side or the other has given prior advance notice that they're going to terminate the tenancy, then the landlord can't just say, fine, I'm renewing, but you're going to have to pay an extra $100 a month. The tenant will have to agree to that. And if the tenant doesn't agree to it, then you can terminate the lease, or, or that's it. They'll have to move out, because if they don't pay the difference, there is no meeting of the minds and it has to be signed. And firearms, I already mentioned that, so we're going to move on. So before you rent your property, you should ask yourself a few questions about whether you're even allowed to. For most single-family homeowners, that's not an issue, unless it's in a condoized development where the house is owned by you, but the land is part of a condo association or homeowners association. But if you're renting out a condo in a building or a townhouse that's connected with others and that is part of an association, be sure you check your HOA documents and the rules and regulations, and do that before you even buy this as an investment property, because most condo associations do not allow rentals less than 6 months. And you may be thinking you're going to have an executive type of tenancy where people come and go for a month or 3 months at a time. That won't work in most condos, and it won't work in most townhouses either. So be sure you know what your HOA allows before you put your property into the rental market. Also, review your loan documents to confirm that you are allowed to rent out your property. Some lenders do not allow you to convert a primary residence into a rental property. I've only had that come up once in the last 10 years. but it is in some contracts. So be sure your lender will allow that. And same with your insurance company. If you move out of your residence and turn it into a rental property, and that's what a lot of people do, trying to downsize, they've got a big house, they want to keep it as an asset, but they really don't need all the space. So they downsize into something else and they rent out their main house. You've got to inform your insurance company immediately, because there are different rates and coverages that apply to rental properties. And if you try to just keep it, on the down low and not tell your insurance company, don't be surprised if when a claim needs to be made that they deny coverage because you did not inform them. So be sure you're upfront with your insurance company about your plans and what you're actually doing on the property. So now let's talk about leases and what should be in every lease, because I can't tell you how many contracts I see where people don't fill out all the blanks on a lease. So be sure you specify, and this is so basic, specify the length of the term. If it's a 1-year lease, say it's a 1-year lease and say when it starts and ends, because sometimes the tenant will sign on one day, but they don't move in for several weeks. Sometimes you can't give them possession of the property because an existing tenant hasn't moved out yet. So be sure you specify the term in the contract. And if not, the law will determine what the term is by how often the rent is paid. So if it's just a roomer who pays weekly rent, that means it's a weekly lease. And if it's a roomer or, a tenant who pays month to month on a monthly basis, then it's a month to month lease. And those can be terminated by either side with just 30 days notice. So be sure you specify the term of the lease and the full amount of the rent for the whole term. If the rent is $1,000 a month, put the term as 12 months and the total amount rent due is $12,000 due in monthly installments of $1,000 per month. Regarding lease termination provisions, under federal law, a military member can break leases. So be aware of that. I'm not telling you should not rent to military members. They make really good tenants by and large. And, they need housing. So I think military tenants are excellent tenants, but be aware that if they get change orders that move them more than 30 miles away from your property, they will be allowed to transfer. And they have to give you 30 days notice, and they have to give you a copy of the change orders. A common provision in leases in this DMV area is that leases can be broken for job transfers. And I see this a lot. And so you do not have to use that provision, but just be aware of it and don't let it accidentally end up in your lease if you don't intend it. So that would allow your tenant to terminate a lease early if they're transferred away, by an employer, or if they just decide to take a new job. These provisions are common in this area, and they're often something that you need to put in a lease to attract a tenant. But it also works both ways. Sometimes, we have clients who are in the foreign service and they want to come back. Or maybe the place where they were stationed has to send everybody back all of a sudden. So the State Department has temporary short-term rentals for their State Department members if they can't get back into their own home. But it's really common for a State Department employee who's renting a property to put in their lease that if they get stationed back here, they can break the lease with 90 days notice to the tenant. So just be aware of these. These are options. It's not required except for military members. They are allowed to break the leases, and that's federal law. I know I'm going fast, so I just want to be sure if you have any questions, you have to write them in, and we'll stop in a little while for questions. But I want to bring up lead-based paint. You have to give a notification with every lease if your property was built before 1978. So if you are somebody who's ever bought and sold a property, this is required for sales of real estate. It's also required for rentals. So just be sure that you have given a tenant, if your property is older, give the tenant the notice that yes, it was built before 1978. And if you know that it contains lead, then answer truthfully and say it does contain lead paint. And if you don't know, say it was built before 1978 and I don't know. But the reason why you want to give the notice is, one, to comply with law, but two, so that you don't end up with a lawsuit several years down the road because you rented to a family that had, toddlers, and they have some brain damage from lead paint that was in the home, and they're coming back to sue you when they're 20 years old, because their statute of limitations on lawsuits doesn't expire until 2 years after they become adults. So I think I've got another slide here, just a second. 2 years after their 18th birthday. So what that means is if somebody is injured at 2 years old and they have a debilitating illness, or they have brain damage or something caused by lead-based paint in your home, if you haven't given the lead-based paint warning, then you don't have civil liability protection, and that person could theoretically come after you until 2 years after your 18th birthday for damages caused in the home that you rented. So this doesn't happen very often, but you will see these ads sometimes. They're out there. That there are protections, and the way you protect yourself is by giving the lead-based paint disclosure and by giving the tenant a copy of the lead-based paint pamphlet. This pamphlet is required to be given to them. You don't have to go buy it anywhere. It's on the EPA's website. So just Google United States Environmental Protection Agency or EPA pamphlet. It's pretty easy to find. It's available online. It's available in many different languages. So just print it off and give it to your tenants and create a form where they acknowledge that they've received it. If you're using a realtor, the realtor will already have these forms in place, and they will have the acknowledgement form for your tenant to sign off on. Another thing that you should know about lead-based paint. If during the tenancy, if more than 2 square feet of lead-based paint are disturbed, meaning you've made a repair, there's a leaky pipe and you decided to repair it, and you've disturbed a small area of lead-based paint, you have to give the tenant a copy of the pamphlet again and get them to sign the acknowledgement again. It does not apply to emergency repairs. So if there's a flood and you've got to repair, you don't have to do it. It's just, these are for repairs or renovations that you know about ahead of time and are not emergencies. Then you do have to give them the lead-based paint disclosure statement again. Okay, and we already saw this statute, so I'm going to skip over that. We should talk about delegating landlord's duties, because for the most part, it's not going to be something that you can push off onto others. Landlords have certain responsibilities under the law. I suggest all of you read the VRLTA. It's not that long. Just Google VRLTA and you'll find the whole statute. And there's not that many sections, and it's pretty easy to understand. None of the sections are extremely long, but basically don't just assume that if you hire others to do jobs for you, like in this case, this photo is somebody who hired somebody to do snow removal, and the subcontractor did a crummy job, and somebody was injured because of the negligence in maintaining common areas. So in this case, the tenant who was injured sued the landlord, and the landlord tried to say, it wasn't my fault. I hired a snow removal company and they were the ones that were negligent, not me. And the jury instruction that the judge gave was that a landlord cannot delegate his duty to maintain common areas. So if you believe that the independent contractor was negligent in maintaining, then that means you have to find that the landlord was negligent. And in that case, there was, I thought I had a slide about that. In that case, there was, I believe it was a $2 million jury verdict for the tenant. So be sure that your hired contractors are doing their job, because you're going to be responsible if they're not doing the job properly. Under tenants' use and occupancy, keep in mind that you cannot restrict a tenant's access to cable, satellite, or antenna services for TV and internet. Some landlords don't want cable dishes on the side of their home, or extra, antennas. Antennas and dishes really don't come up that often. In my practice, it's maybe been twice. But it is a matter of federal communications law that a landlord cannot restrict a tenant's access to those things. The tenant has to pay for the communication services they want, but you can't say no to allowing it. Regarding applying pesticide or insecticide, you have to give the tenant 48 hours written notice. And these are just miscellaneous things that are in the code that I want you to know about, because these are common things where landlords trip up and make some mistakes. Under use and occupancy, make sure your lease says that the tenants will be using the dwelling only as a residence and not to run a business. And why this is important, it's because there are businesses where if it's not stated in the lease that it's going to be used only as a residence, some people do run businesses out of their home. Now, if you were just having me as your tenant, I can run a law practice out of my home and never have anybody come into it, and it's not going to cause a problem. But if I'm running a daycare or animal boarding and grooming or car repair out of the home, and these are all examples that have come up in my practice, it does cause a problem for the landlord because it bothers neighbors. It causes, these types of businesses can cause a lot of liability issues to arise, and they can also cause a lot of personal damage to the, property damage to the dwelling unit. And I think I've got a couple pictures here of damage that have been caused by landlords running business. So this shot here is not a shot of damage, but it's just an example of a house that was being used to a daycare. The landlord represented, the tenant represented to the landlord that it was just two adults living there as the tenants, and they had no kids. And if the landlord had inspected, they would have seen this set up in one of the family rooms. And, for a couple with no kids, this would be an odd thing. But that would have been the landlord's tip-off that there was a daycare being run out of the home. And so daycares cause a lot of problems for neighbors because of the drop-offs and the noise of, a lot of activity on the street. Sometimes the noise of kids, a lot of kids out in the yard disturb other neighbors. And it's just something that you don't have to allow if you're a landlord. So I think, this one was a bordello. Looks like just a normal house. Somebody was running prostitution services out of the home. And this was in Arlington. And then I've had another case where somebody did a lot of damage running a dog grooming business, boarding and grooming out of a townhouse. And so that was a huge problem for other residents. And she did a lot of damage to the carpets and the hardwood floors. And the security deposit was not enough to cover the damage that was done. So moving on, subleasing and assigning rights to be a tenant in your property. My recommendation is to not allow it, and make it clear in your lease that subleasing and assignments to other tenants is not allowed. The VRLTA says that the landlord can approve or disapprove an assignment or sublease, and that if the landlord doesn't answer, if a tenant says, I want to sublease my place, I'm leaving, and the landlord never responds, under Virginia law, it can be a valid sublease if there's evidence that the landlord didn't respond at all. It can just amount to approval by non-action. So be sure your lease doesn't give the tenant any right to sublease or assign the property. And I don't have the ability to hear what you're thinking or wondering right now, but I want to make sure everybody knows what a sublease is. That's where you're allowing somebody else to assume your lease, and you've got a subtenant, and they pay the rent to you they pay the rent to you as the tenant, and then you as the tenant pays the landlord. So sometimes that can be really profitable for a tenant, especially if rates have gone up a lot. And so they can put in several subtenants. who are paying more to the tenant named under your lease. And then the tenant, so the tenant, if the tenant is successful in subleasing the property, they could be collecting $3,000 or $4,000 a month, and they're only paying you $2,000 a month. So that's one reason why you don't want it to happen. The other reason is you don't know who's in your property, and you don't have any idea of whether they're financially qualified, whether they have criminal records, all kinds of reasons why you need to know who's in your property. And that's why I don't recommend allowing subleases. An assignment is where the tenant just completely assigns their rights under the lease to somebody else. And then the assignee, the new tenant, would pay the rent to you, not to the subtenant. And I mean, not to the original tenant. So again, these are just complications that allow other people into your property without you knowing who they are and without you approving. So I don't recommend that you allow subleases or assignments in a residential lease. Let's see. Access to the premises. Remember at the beginning, I said that under the old law, if you didn't have it in your lease, the landlord would have no access, just assumed. Now the law is that a landlord definitely has access to inspect the property, to show the property, to make necessary repairs or agreed repairs, and even for realtor showings. But they have to give, for non-emergency access, you have to give the tenant 24 hours notice. If there's emergency access needed, like a major water leak or a fire or something like that, the landlord does not need to get the tenant's consent ahead of time. We've had a lot of issues this year because of COVID with landlords wanting access for things like realtor showings or to make routine repairs or even inspections. And the tenants have refused because they don't want anybody in their property during a pandemic. And for the most part, we were able to get around lawsuits to enforce the access to the premises, because really, I think any judge this year would have said, no, I'm not going to allow the landlord in just to show the property for a realtor to sell the property at the end of the lease or to get a new tenant. And it's just, this is the way the law has been this year. And I think that next year, when things get back to normal, that might change. But don't count on being able to show your property through realtor showings in the last 3 months of the lease. It might be in your lease, but that doesn't mean the tenant is going to cooperate, and it doesn't mean that it's going to be good for you as a prospective landlord to somebody new, or as a prospective seller, to have the tenant in control of the way the property is presented. Because I think most tenants don't really care about how the property looks to other people when it only benefits the landlord to have it clean and tidy for a realtor showing. So that's about all for that topic. This is just illustrations of cases that we've had in our practice showing why a landlord should never give up their right or abandon their duty to keep regular inspections of a property. In this case, the guys that rented it turned the place into a frat house, and the landlord just never checked on the property. And so this went on for years. If you're a landlord, put in your lease that you have the right to inspect at reasonable times. I think every 6 months is reasonable. Some people want to inspect more often than that. You're going to have to work that out with your tenants on an individual basis. I think once a month is unreasonable. But you don't want to get that into an issue. Just let your tenant know up front what your plans are going to be for inspecting, and then follow through. If you have a property manager, make sure your property manager is doing the inspections. And if you're managing it yourself, make sure you do it. In this frat house case, this is what the place looked like. As you can see, the carpets were ruined. The stairs, the walls were filthy. They painted several rooms completely black. I think this was the dining room, because you can see it's a first floor room. This took many, many coats of paint to cover up black. And so there was so much property damage. Oh, that was a hoarder. In this case, there was just so much property damage that security deposit didn't even come close to covering it. And the landlord was just never able to recover their losses by suing the tenants because they were all uncollectible. So that's another thing you should keep in mind. If you're planning on suing tenants to recover whatever property damage they've done, they might not be collectible. So you've got to keep in mind that's one reason why you want to inspect the property to make sure that it's not being damaged before it gets to be too expensive, and to make sure that you screen your tenants so that you know whether they've got a steady income and a job and they're going to be collectible for any future judgments, and get that security deposit paid in advance. I've had lots of tenants, or lots of landlords come to me and say, the tenant moved in, they were supposed to pay 1 month's security deposit, 1 month's rent in advance, and both their checks bounce. And they moved in, and here the landlord is with not a single dollar because both checks were bad. So make sure that you clear the payment first and that you have it in hand before you allow anybody to move into your property. Again, here's why you need access to inspect and that you actually follow through. This was a case of hoarding. In this case, the tenant lived there for years, I think 10 years, and he had drilled holes. You'll see at the bottom of this door here, there's about a 3-inch hole. He had ferrets that he let run free throughout the whole house. So every single door had a hole drilled in the bottom of it like that. This was a nurse who had issues. She had, issues with housekeeping. She had vials of, or big jars and bottles of urine all over the place. She had medical waste. These are our heroes this year. I'm not trying to, slam on nurses, but this is an example of how some people live. This person hoarded cats. And it's hard to tell from this picture. And by the way, pets weren't allowed on the lease. But this picture shows after the cleanup how badly damaged the floors were from the cat urine. The pet urine will soak through wood, and these floors had to be replaced. The 1-inch, you couldn't just sand down 1-inch boards to nothing. They were completely black all the way through. This case was a meth lab. I've had at least one meth lab case in my practice, and that was at an apartment building. The cleanup cost was unbelievable. The landlord had to hire the people in the hazmat suits to come in and completely remove all the drywall, all the carpet. They basically had to gut the place. And actually, the law now requires that if there was ever a meth lab in your property, you have to disclose it to future renters, so that you have to disclose that there was meth lab remediation done in your property, because there is residue that can remain permanently. Let me see what time it is. Does anybody have any questions yet?
Yes, we have several questions. I don't know if you want to take them. I'll start with them.
Yeah, let's take it. I'm probably going to break several times for questions, if that's okay.
Okay, I'll start with the first one. Is there anything such as an oral lease?
Yes, there is. An oral lease is just a spoken lease where you haven't reduced it to a writing, and those are enforceable. Those happen a lot with family members. I've got a case right now where a family member has to evict other family members that they've allowed to live in the home. So if you've allowed somebody who's not the owner to live in your home, that is considered an oral lease, even if there's no rent required. It's just an oral lease for no rent. And once somebody is a tenant, they have rights. And to terminate the tenancy, you have to give them a written 30-day notice that their month-to-month oral tenancy is being terminated. The notice has to be hand delivered and or mailed and or sheriff served. Make sure they get it is the bottom line. Post it on the door is another way to do it. keep good records of how you do that service of the notice and keep a copy. And there was something else I was going to say about that. I'll think of it in a second. But, oh, the month has to start at the beginning of a calendar month and end at the beginning of a calendar month. So today is what, the 22nd or 23rd of May. If I was going to give somebody a 30-day notice, I can't say your tenancy will end June 23rd. I would have, if I gave the notice now, I would have to say your tenancy ends on June 30th. So you have to give a full calendar month notice.
Okay, thank you.
Sure.
We have another question. Do they have to give a paper copy of the EPA pamphlet, or can it be an electronic one?
Well, what I recommend is that you give people the link right in your lease, so that they can, but you do have to give them the paper copy. Yeah, so just print it out. It's not that big of a deal. But put the thing put the link in there too. Honestly,
Okay.
it's never come up in my practice as an issue, but I would err on the side of caution because of the potential for future lawsuits down the road.
Okay, we have a question from Karen now. It's for a single family house, can lease require tenant to do snow removal?
Yes, it can. As long as it's clear in the lease and the tenant agrees. Yeah.
Okay. Now, I have another question is, how can a landlord be not be exempted from the new law that appear on repair and deduct?
Repair on the what?
And deduct, it's a new law that was approved where the landlord, where the tenant can do the repairs and deduct from the rent.
That's not a law that I know of. I've never heard of that.
Okay.
In fact, that's really not allowed in any, and that should be very clear in any lease. Tenants often think, oh, I don't like the way this faucet is working, and they may be valid complaints. My stove is not working, so I'm going to just get a new stove and deduct the cost from my rent. You're not allowed to do that. The tenant has to give the landlord written notice of whatever the thing is that's not working. And if the landlord doesn't respond within a reasonable time, and that's usually 30 days notice, the tenant can file what's called a tenant's assertion action. And you file that in the general district court. The tenant would file that, and they would start paying their rent into the court. They have a registry and an escrow account to keep track of tenants' rents that are paid into court for a tenant's assertion action. So what that means is the tenant is asserting that there's a condition in the home that is unsafe and that needs repair, and that the landlord's not doing anything about it. And these matters come up on the court's docket on an expedited basis, so they will be heard relatively quickly. And the judge will decide who gets to keep the money, whether it goes back to the landlord or whether the tenant rightfully is not paying the rent and the landlord has to repair the item.
Okay, thank you for that. Now
Sure.
we have another question.
Let me say one more thing. I'm only talking about Virginia law here. That repair and deduct thing may be the law in other jurisdictions, but it's not in Virginia.
Okay, thank you. We have another question. Is in Virginia now, with all the fuss about criminal history or people that has been released from jail, what we can do in regards of renting to someone or not renting to someone with criminal history?
So under fair housing laws, you have to not discriminate against anyone in a protected class, and that's coming up later on in this presentation. But having a criminal history is not a protected class, so you can discriminate against people who have a criminal history. I'm saying you can screen against that. It's not a protected class. So if you don't want former criminals in your property, you don't have to rent to them.
Okay. Another question we have is let's say you find a hoarder in your property. Can you fix and use the security deposit for that without terminating the lease?
Um, well, the way any lease is worded, or most leases are worded, is that the landlord can use the security deposit to make repairs that are not the landlord's fault. So if the tenant damages something, the landlord can use the security deposit to repair that and then demand that the tenant replenish the security deposit. That really doesn't work as a general rule. Tenants aren't going to go for that. And it works in commercial leases more than in residential leases. And hoarding is a especially problematic area because hoarding is also considered a mental illness in some cases. And you have to be very protected. You have to be very careful that you don't violate the tenant's rights regarding housing availability to them as somebody who has a disability. So if they have a mental illness, they're disabled, and they are going to be entitled to reasonable accommodations under the law. It doesn't mean you have to allow the hoarding condition to continue, but it does mean you're going to have to give the tenant notice and probably extra time to fix the hoarding, to remedy the hoarding situation in the home with that before you could just evict them. You probably will not be able to get them out fast. In cases where we've had hoarding, they usually need several warnings. It usually takes a long time. So that's why I'm saying inspect and do a background check on your tenant's rental history. Call former landlords. You can also look on the court's website. If you just Google Virginia courts, you will find a link to all the general district courts in the whole state. And there's some drop down tabs on the side. And so you would just drop down to Arlington County. And if I were you, I would search for neighboring counties too and see if this particular applicant who wants to rent at your property has ever had an eviction in Arlington County, Fairfax County, Falls Church City, Prince William County. I mean, all the nearby ones I would check, because it's really easy for you to do that. It doesn't cost you anything. And if you see their name and you see that a prior eviction with an award of damages, that's not just rent, that, property damage, then you may want to contact that landlord and see what the issue was.
Okay, thank you. We have, those are all the questions we have so far.
Okay.
Thank you.
All right. So back to tenant selection, which I hadn't even started yet, but the gist of this segment is to be very careful in selecting your tenants, and like I said earlier, get some professional help for doing financial screenings, because there's no way for you to do an adequate credit check unless you're in this business. You don't have access to the databases that can run credit screenings on people, or the forms necessary to give them permission. For them to give you permission to do the credit check. So do a credit check, make sure that they don't have outstanding legal judgments against them. Verify income. So if they've stated who their employer is, call and make sure that they really are still employed there, and what their income is. And you also have to be careful that you don't violate fair housing laws. This is probably dating me, because I used to watch the Brady Bunch when I was growing up, and this was, the perfect American family. This is not how most American families look anymore. And you have to follow the law, and you can't discriminate. And what that means is that under federal law, there are 7 protected classes: race, color, religion, national origin. So that's, discriminating against somebody based on where they're from. Sex, so that's gender. Disability, or familial status. So that's where you get into discriminating against families with kids, that kind of thing. So those are the 7 protected classes under federal law. Virginia has even more protected classes. They have all the federal ones, plus elderliness. So you can't discriminate against somebody for being elderly. Source of funds. This is a new change to the law. You can't discriminate against somebody who had an eviction during COVID. So especially if they applied for protection under the CARES Act. So be careful that you don't follow, or that you don't violate this one, because that's a new law, and you'll have to look. I didn't put the, I can get back to people and put the actual statute number on that. I'm going to make a note here. This goes into effect July 1st, so I just didn't have it at my hands, but I will get that for you. Sexual orientation, gender identity, and veteran status. So these are all relatively new in the big scheme of things. The general rule of thumb is just don't be a jerk. If you try to discriminate against somebody, you're going to get caught. And you're also, and if you get caught, the expenses and fines are huge, and you're going to need a lawyer to defend. So you're looking at, in this area, I charge $3.75 an hour. I think that's what most people in this area charge, or more. And so this could cost you a lot of money. And the first thing that will happen is you will get a complaint that the tenant files with the local HUD office with all the allegations against you, and you have to respond to that complaint. And it's a long form. It's maybe 15, 20 pages. And you have to be very careful how you respond. So I would recommend, if that ever happens to you, don't try and respond yourself, get a lawyer. When you're screening for tenant, or when you're selecting tenants, make sure you know how many people are going to be occupying the place. So you have a rental application, or you should have a rental application for anybody who's applying for housing in your unit. You have to have them list everybody who will be a tenant under the lease. And by tenant, I mean that's an adult who is named as the responsible party for paying rent and for any other violations. Other occupants can be people who are not financially responsible under the lease, but who are allowed to live there, such as children or elderly parents or other relatives, whatever. But all authorized occupants should be listed on the rental application. And then your lease should say that the rental application is considered a material part of the lease and is incorporated into the lease. So if the tenant has lied about who was going to move in, that would be a default that you could enforce by saying you've got unauthorized occupants living in the property, you have 21 days to cure this problem, or the lease will terminate in 30 days. That's what's called a 21 30-day notice. So be sure you set the number of occupants, know that you know who's going to be occupying your property, and that you set the number of occupants allowed according to housing building code occupancy limits. So the space requirements for a bedroom or sleeping area under most building codes is 70 square feet allowed for one person, 100 square feet for two people. So that's a small bedroom. That's 10 by 10. Two people are allowed to live in a two-bedroom, in a 10 by 10 bedroom. And 150 square feet, you're allowed to have three people reside in that bedroom. So what that means is you can't have a lease where you say, sorry, this is a one-bedroom place. I don't have room for a couple with a baby. That won't work. The other thing about authorized occupants, I forgot to mention, is that whoever's listed on the lease is allowed to have their children live, even if they have not identified them as authorized occupants under the lease, because that child wasn't born yet or wasn't adopted yet. Or maybe there was a custody issue and the person didn't have their child living with them at the time they applied, but then the child's moving in. They are allowed to have their children living with them. So you can't violate somebody or tell them that they violated the lease because they have their own children living in the place. And that applies to biological and adopted children. Back to the building code occupancy limits and general rules about what you designate as a bedroom. A bedroom has to be used for sleeping. A bedroom that is to be used for sleeping must have privacy. So that means it has to have a door. It has to have adequate light and ventilation. So that means it has to have a window. And it has to have two means of exit, one that leads directly outside. So that's pretty easy. If you think about any bedroom, it's got the door into the room from the hallway, and it's got a window to get outside. So that's easy to qualify most standard rooms. But the problem that people get into is where they've got um, bedrooms, or they've got rooms in their house that they want to rent out as bedrooms, and they list the place as a 3-bedroom place, but 2 of the rooms are in the basement, and they either don't have windows or they have those little tiny basement windows. That would not qualify as a legal sleeping room because it doesn't have a means of exit directly to the outside, a legal means of exit. I think I have a picture here. This was advertised as a bedroom, but that's not a legal bedroom. So don't advertise rooms that have those kind of windows as bedrooms. You can call it a den, you can call it an office, whatever you want, but it's not going to be a legal bedroom unless you put in one of these things, the window well with a larger window. And these are not that expensive to install. I mean, in the big scheme of things, I think these units cost about $2,500. But you've got the labor, if you don't know how to do it yourself, of digging out below the foundation, installing the new window, making sure there's drainage. You'll see the drainage pipe here, so this thing doesn't fill up with water and flood into the room, and putting some sort of barrier to keep intruders out, or people from falling in, or animals from falling in. But you can't, if you have a screen like this over it, you can't put a lock on that because that would be deadly in the event of a fire. And I think I had something here that I missed. Nope, that one. Okay, so okay, no, I covered everything on that slide. So anyway, those are just things to be aware of so that you don't get yourself into trouble for false advertising or for illegal tenancies where you've got rooms that are not legal bedrooms. Back to screening your applicants. This is really the single biggest mistake landlords make. And again, I understand. I've been a landlord before. I understand how exciting it is to finally get somebody. You spent money renovating a place, and now you're going to get a way to pay for the place. You've got a tenant that looks like a good person, and you want to rent to them. But there's a lot of people who look okay on paper or look okay when you meet them face to face, but you've got to request information that allows you to make a clear, level-headed decision about whether they are financially qualified to be your tenant. So again, you don't ask illegal questions like where you're from or your race or religion, but you do run a credit check and a background check. And then you have to verify their income. And then you should look at I'm going to tell you this story in a minute. You should, I've got a slide. I'm sorry, I'm jumping around. The income qualification guidelines should be what you use when you verify their income. You got to make sure that they can actually afford it. So the federal guidelines recommend that a family should not be spending more than 30% of their gross income on housing. So that rule of thumb would be 40 times the monthly rent is the tenant's income. So if the tenant is paying $1,500 of rent, they need to have 40 times 1,500 as their annual income. So that would be $60,000. In this area, I think tenants often spend more than 30% of their gross income on housing because this is a really high income or high expense housing market. But those are the guidelines that are out there. And so really, if they're spending 50 or 60% of their gross income on rent to you, the chances are they're going to get into trouble down the line. And that would be somebody who's just not qualified to rent your property because they don't have enough income. Back to what I wanted to tell you a story about one guy, about how somebody can look like a perfect tenant. So this was a guy, I had a client who owned a condo in a really nice building, and they had moved away and they wanted to sell the condo, but it wasn't selling because the market was way down. So it was for sale or for rent, but what they really preferred was that the place got sold. So they let their son-in-law, who was a realtor, um, list their condo, and he was listing it for sale or lease, but he knew the parent, his in-laws, wanted to sell it. So along comes a guy who's a doctor, and it happened to be the son-in-law's actual doctor. So he knew him a little bit, and he trusted the doctor. And I think he just also was, was impressed that this is like the dream tenant for my in-laws. He's a doctor. Doctors are rich. Doctors will be fine. So this guy, the doctor, showed the realtor son-in-law a pre-approval letter for a $1.6 million mortgage, and he said he wanted to buy it. So he showed it to him. He liked it. He had said that he had no prior evictions, no pets, no smoker, but he didn't put that in writing. He just said that to the son-in-law. Son-in-law didn't do a background check at all. He just took the $1.6 million mortgage approval letter at face value. At some point, the doctor called and said, I'm opening a new practice, and I think what I want to do is rent for 6 months, and then after we get the practice opened, I won't have so many, credit checks and issues with my partners on setting up equipment and all the expenses of opening a new practice. So I just want to be a renter for 6 months, and then I'll buy it. And then the son-in-law said, fine. And he said, I want to take one more look at it. The son-in-law said, fine. So he gives the doctor the code to the lockbox, and the doctor moves in. So not only does he not have, he's representing his in-laws, so he's got to tell his mother and father-in-law, I've got somebody in there. I let him in. I trusted him. There's no lease. There's no application. There's no credit check. There's no knowledge of really, what his income is. And there's no money has been exchanged yet. There's no security deposit and no first month's rent. And so they had to evict this doctor, and they had to hire me. And we have to, I treated the doctor as somebody who was not a tenant because he had entered under false pretenses. So we gave him a notice to vacate immediately, and said, you're basically a trespasser. You have no right to be there. You're not authorized under lease or anything to live there. And he'd moved in with a wife who smoked and with a pet. So we didn't have to give him 30 days notice because he had not become a tenant. He was treated as a squatter, but he fought it. And this case took place in Falls Church City, where we use Arlington's judges. So they only come here 2 Wednesdays a month. So it's really hard to get on the trial docket in our Falls Church City because we run a part-time court. So it took them a couple months to get a trial date, and then they had to pay me to get ready for a whole trial. And so it cost them probably 10 grand in legal fees to get this deadbeat out. And it turned out the doctor was being sued for medical malpractice. He had split from his partners. He wasn't opening a new practice. The $1.6 million pre-approval letter that he had given to the son-in-law was fake. He had just made it. When I called the mortgage company to say, did you issue this pre-approval letter to this guy? And they said, no. What state are you calling from? And I said, Virginia. And I gave him the name and the guy's information. They said, we don't even sell mortgages in Virginia. We are a Florida company. We've never heard of this guy, and we don't do business there. So he had just, screenshotted their letterhead and created a pre-approval letter and gave that to the son-in-law. So that's the kind of thing, if you just make assumptions that you have the perfect tenant, I am of the opinion, I'm such a skeptic because of the nature of my business, but it's like, if you want to trust somebody, fine, but still verify. Because for most people, this home is one of your major assets, if not the biggest asset that you own, and you've got to be careful about who you let in there. So don't just make assumptions that somebody's okay. You've got to do the work to do the background check, and meet the tenant in person. Again, they should be naming all the adults on the lease. If it's roommate situation, boyfriends, girlfriends, they should all be identified. Indicate on the lease whether each adult is a tenant or just an authorized occupant, and know the difference between them, because you cannot collect money from an authorized occupant, only from the tenant, because the tenant is the person who's financially responsible. You will think of them all as your tenants because they're all allowed to live there. But the only person or the only people who you're allowed to collect rent from are the people who are named as tenants, or guarantors. A guarantor is, most of you are going to be familiar with the term cosigner, and this comes up. It came up with my own kids when they first rented their apartments, because they've got no real credit history, no real work history. The landlords wanted the parents to co-sign the lease. So that means we are not tenants in the sense that we have any occupancy rights, but we are financially obligated if the named tenant blows it and doesn't pay the rent or gets evicted for some other reason. We would be financially responsible for property damage, for unpaid rent, for legal fees. So that's what a guarantor or a cosigner is. So be sure you know the differences and that you are clear on the lease who is what. My recommendation is that you always rent to people, not to limited liability companies or corporations. You will get applicants, or some of you will get applicants asking to rent in the name of their business. I say don't do it. Tell them, look, this is a home I am renting as a residential property. You're going to have to put this in your own name. And the reason why is because there are different rules about how a business is service of process if you have to evict them. Entities are easily dissolved. They often have no assets at all to pay a judgment. Whereas a person, if you're suing Martha Mothershead, the attorney, versus Martha Mothershead LLC, the business, or Mothershead Law LLC, that doesn't exist. But the difference is my business may have no assets or I dissolve it. But if you got a judgment against me in a court for a money judgment, I personally would have to pay that judgment, not my business. So that's why I say rent to people, not corporations or LLCs. The rental application, I think we've covered that pretty well. I've already said everything on this slide. Let me see where we are in time. Require a photo ID. Landlords are allowed under the law to ask for a copy of the applicant's driver's license or other similar photo ID, and they're allowed to ask for social security numbers. So be sure that you verify who's going to be in there. This is the income qualification we already discussed. You should be aware of common scams involved in the residential housing area. So if you're not using a realtor and you're going to try and market this yourself, that can be a pitfall for people who are going to scam you or your prospective tenants. And I know you're not responsible for other people who are out there looking to rent your place, but what happens is sometimes people will grab a screenshot of a photo. If you put a photo of the outside of a place on your listing, they will, or even the interior shots, they will grab those photos, create a dummy ad, and invite people to apply for rent at your property, but you know, the person applying is responding to a fake ad that some scammer has created. And so the victim of that is not going to be you, but it's going to be other people who are out there looking for places, and they often will pay application fees and sometimes even first month's rent to fake landlords who don't own the property and can't rent it out in the first place. So be very wary of Craigslist ads. Be very wary of the overpayment scam, where the tenant wants to send you a check for more than what is required by you, or they'll say things like, I hope you don't mind, but my employer gave me my whole rent allotment at once, or I'm moving here and this is the check I was received. Can you just deposit this whole amount in your bank and give the overage back to me? Those are red flags that should alert you that this is an overpayment scam where a bad check is going to be issued. And that's where the case, I don't know how banking really works, but some checks that look good, they're certified checks, um, they are fake, and the banks can accept them, and then once they try to negotiate them, they find out they're fake. I don't know how a certified check, I mean, the whole point of a certified check is that it's certified, but people are able to do banking scams and all kinds of other scams. I'm not an expert in scams, but it happens. So watch out for overpayment scams. This is one where our landlord had received a request like this. It's, you know, I reprinted for you part of the actual email from the prospective tenant. He's saying, this is an international situation, and I'm not sure how you can run my employment and credit check background because, you know, I'm overseas. I can't go about it until I get there. Hope you understand. Don't rent to people like this. That's a scam. There's another one. I think I have another one. No. Well, you get the gist of it. That's watch out for scams. Avoid Craigslist if you can. Use a realtor if you can. Then you know that somebody else who's licensed is going to be showing their property and using the property listings that all realtors share and use. A good place, though, if you're going to try and market this yourself, is ahrn.com. This is a place to market your property to members of the military. So that's a website where you're going to find military tenants. Other tips on being a landlord is don't assume that your tenant will know anything about how to take care of a property or how to manage it. So explain to them what the breaker box is and what it does, how you can turn off power in certain places by just flipping a switch. Or if the power goes out in one area, show them the map here that says, you know, like kitchen is switch number 10. And if the power goes out, then you don't have, because your tenant's overloaded the fuse or the system, doesn't mean that you have to pay the cost of having an electrician. They can just go flip the switch back on. And explain to them the types of powering scenarios that can cause a breaker switch to trip. Let's see what else. The backs of washing machines are a frequent and really common source for leaks. And these can be really expensive to you if you own a property that's in a multi-story building, because the water damage can flow down to neighbors and you can be held responsible. So get one of these flexible hoses with a screw-on coupling, so that if the tenant's overloaded the machine and it's shaking and wobbling, it's not a rigid pipe that just pops off. This has a little move for give and take like that. And explain to your tenants how to properly use a washing machine and dryer. We have front load dryers that front loading washers that tend to mold in the rubber gasket where the door is. So, you know, we know to leave our door open between washes so that it's not always wet in that area and potentially growing mold. So if that's what the type of equipment you're offering, explain to them what they have to do. If you've got a high efficiency washer, tell them what type of soap they have to use. They have to buy the high efficiency washing machine soap. They can't just use anything. Don't let your tenants paint. I guarantee you they will do a bad job, and they will pick a color that's going to cost you a fortune. I had a client call me recently about they had let some young women who were renting their very first place move in, and they gave them permission to paint. And because the landlord really didn't feel like doing the turnover costs and repainting the place themselves, and so these girls painted the living room pink, and they dribbled paint all over the moldings. They dribbled paint on the marble fireplace. What's it at the bottom of the fireplace? The skirt, I guess you'd call it. They just did a terrible job, and they painted it a terrible color. So when they moved out, the landlord had all kinds of, they got paint on the carpet too. So the landlord had all kinds of other damage to deal with, and of course trying to collect for that damage, because the security deposit wasn't enough to recover all of the landlord's losses. that would have meant a lawsuit. So the landlord didn't sue the girls. They just, kept the security deposit and ate the difference. But that's a situation you can easily avoid, but just don't let in your tenants paint. If you have shutoffs, show the tenants where they are. If you don't have a hole already cut in your wall to access the shutoffs, you can buy these plastic inserts from Home Depot or Lowe's or any hardware store. Really, they're maybe $20, and you just cut with a drywall knife, cut a hole open, and insert this little door. But this isn't fully built yet, but there's a plastic door that would shut over this, and show their tenants how to turn off the water if there's a problem. Same thing with faucets outside. If you're going to allow your tenants to winterize your faucets, don't assume they're going to do it, and don't assume they're going to do it right. So for winterizing outdoor faucets, I really suggest that you either do it yourself or hire a service to do it. That can be a huge expense, having a pipe explode because the outdoor faucet wasn't winterized. That's a breaker box. Okay, let's talk for a minute about terminating tenancies, which I hope none of you will ever have to do, but it does happen when tenants don't pay rent or when they violate leases. So in a non-payment case, if a tenant doesn't pay rent, and they will start to give you excuses right away about why, give them a non-payment notice. So it will say a 5-day notice is typically what's required. Right now, this year during COVID, and through the end of, I think it's through the end of July, but it might go longer. This year, we have to give 14-day notices for non-payment of rent cases. And in fact, this year, most of the COVID rules for non-payment are different than what they have been ever in the past. The tenants allowed extra time to pay. They're allowed extra time to apply for rent assistance that's been made available under federal law and under Virginia law. If the landlord owns more than 4 rental properties, the landlord has to offer the tenant a chance to participate in a repayment plan. So there's lots of other one-offs that are just because of this year of COVID. So know what they are. If you've got a situation this year with a tenant who's not paying rent, this 5-day statement is not true under, that I've put in this slide. This slide has actually changed. It's 14 days required for non-payment of rent, and all kinds of other things. You have to give them notice of what their rights are, how they can get help, lots of things like that. For non-rent related lease violations, so that would be maintenance, not maintaining the property, noise, smoking, whatever it is, you have to give them what's called a 21 30-day notice. So that says to the tenant, you're violating section such and such of the lease. This is what your violation is. This is what your duty was under the lease. You have 21 days to cure this violation, or your lease will terminate in 30 days and you'll need to vacate. If they don't vacate, what a 21 30-day notice means is that you can file suit for the violation if it's continued. It doesn't mean that you can just throw them out. With a holdover or a month-to-month lease, you have to give them minimum 30 days notice. I think I talked about that already. With dangerous or criminal activity violations, you can serve a notice to vacate immediately. And it immediately used to mean, literally vacate today. Trying to enforce that, though, is another matter. So like in the case of that doctor that I talked about, we gave him a notice to vacate immediately, but he didn't. So then your next step is you can file suit right away. So you can't throw anybody out. That is called, let me just back up a minute. There was something I wanted to say about this. For the dangerous or criminal activity, actually, we've got a slide coming up about that because pot smoking has changed. The vacate immediately notice now means 72 hours. So if you give them a notice to vacate immediately, you have to say, if you're not out within 72 hours, I will be filing suit. And then you can go to court. Theoretically, you can go to court and get an expedited hearing. I've never had that happen where we actually got a faster hearing date. But often with the dangerous or criminal activity violations, the person's in jail. So it didn't matter that they didn't vacate within the 72 hours. We were able to get a lawsuit filed right away and get them out. There was, I'm losing my train of thought. I'm sorry about this. Oh, about having to file suit for any of these violations. If they don't pay, if they don't cure the defect of whatever they're doing, if they have stayed too long, even if there's dangerous or criminal activity, you cannot take self-help to get them out. So what that means is you cannot change the locks, you can't turn off the utilities, you can't go in and throw other stuff outside. You just cannot take self-help. It's against the law in Virginia, and there's pretty stiff penalties for violating that. Things that you can prohibit. There's actually a lot of things that you can prohibit in your rules and regulations section of your lease. If you're in an HOA, you have to give the tenant a copy of all the HOA rules and regulations, and you put right in the lease that the homeowners association rules and regulations are attached. They can also be found at such and such, and put the link in your lease and say they are all incorporated by reference into my lease, and a violation of those rules is a violation of the lease. So that way, if you've got tenants who are parking in other people's spots, or they're not picking up after their dog in common areas, or whatever the violation is, they're being obnoxious at the pool, you can get them out for not for violating the HOA rules. I'm just going to talk a second about pets, because that can be another whole class in itself. Pets, you definitely can prohibit in a lease. You also can allow in a lease. If you choose to allow pets, I recommend that you put a pet addendum with your lease, that you describe the pet in detail. So it's a poodle that weighs 75 pounds. Its name is Buddy. The vet is such and such. I put all that identifying information and a photograph of the animal on the pet addendum and say, this is the only pet allowed. The pet deposit is usually $500. Some people charge extra pet rent that, it can be anywhere from $50 a month to $100 a month. I don't think most tenants go for that. So it's better just to get a pet deposit if you're going to allow pets. And also there should be a section saying that if the pet damages anything in excess of the pet deposit, that the tenant is responsible for all damage caused by the animal. So when I'm talking about pets, I'm talking about a different type of animal than service or assistant animals. Pets are just pets. Like I have a pet. I don't have a disability. He's just my pet. If I was blind and I had a dog who was a seeing eye dog, that's considered a trained service animal. So you cannot prohibit a service animal. And there's different rules about assistance animals. You cannot necessarily prohibit an assistance animal, especially if the person has a disability. You can prohibit the animal if it's destroying your property, or if it's biting other residents in the premises, if it's barking all the time, then yes, you can take measures to remove that animal. A tenant cannot just live in a place and violate everybody else's rights of quiet enjoyment to their property. But you be very careful about saying no to animals in general, because some animals are going to be allowed under Fair Housing Act. Somebody who wants an assistance animal due to a disability, they're going to have to give you a letter saying that they have a disability and they need the animal to so that they can fully enjoy the benefits of living in the property. So sometimes that's just because of anxiety. They need an animal to calm them down. There are lots of people out there who are falsely representing that they have a disability. The thing is, you can't ask what the disability is. So you are entitled to ask for documentation of the disability, and that would be really just a letter from a medical provider, and it can be just a psychologist. It can be another type of therapist that is not a doctor. And that can just be a letter that says this person has a disability and needs the animal to live with them in order to fully enjoy the benefits of the housing. And so you can't ask for any more proof like medical records, that kind of thing. Or then you're getting into discrimination based on disability and violation of HIPAA laws and that kind of thing. So be very careful when dealing with service and assistance animals that you just don't say no, because the law does require some yeses. And so you may have to allow an animal, even though you don't want an animal. This was just my slide about self-help evictions these are old tools that people used to use to jam up locks, that landlords used to use to jam locks to prevent tenants from being able to get in. These kinds of tools are now just museum things now. You cannot use them. You cannot take any self-help to lock somebody out of a property without a court order. So this is what people think of when they think of eviction. This day and age, this rarely happens where you're going to see junk piled up on the street. And one is most municipalities don't allow this. There's going to be fines that will be assessed to you as the owner if the tenant just piles stuff up on the street, or if the tenant moves out and doesn't take their stuff and you just pile everything up. Most tenants will get their stuff out, because if stuff is piled up like this out on the street, it's going to be gone within an hour. It'll be picked over and gone. When you get it, if you sue somebody and you get a judgment awarding you possession of the property, you still cannot just go back to the property and change the locks. You have to wait for the sheriff to come back and supervise the eviction. So after winning a judgment in court for possession, the next step is that you have to get what's called a writ of possession. So that's another document that requires that you wait 10 days after the judgment, because the tenant has a 10-day appeal period in which they're entitled to appeal the judgment against them. And then you mail in the writ of eviction, you pay the writ fee, and you have to wait for the court to process that writ and send it to the sheriff's office. And in Arlington, it's really, they're just sending it downstairs. But they have a lot of these to process, and they're going to have a lot after July 1st. I think it's going to be crazy. But they have a lot of these to process. So under the law, sheriffs are allowed up to 30 days to serve the writ of eviction. So that's what I mean. There's time limitations built in and everything. If you file a summons for unlawful detainer, and that's what an eviction action is called, you cannot generally get a hearing any sooner than 21 days after you file it, because the sheriff has to have time to serve it on the tenants. And just because that's how backed up the courts are. Once you get that hearing, the first hearing is called a first return. And that's the date that all the parties are supposed to come to court. So either you come to court if you filed yourself, or if you've hired an attorney, your attorney will come to court, and the tenant comes to court. If the tenant doesn't show up, you can win a judgment for possession and for the unpaid rent at that first return just by default, because they haven't showed up. But if they do show up, they're entitled to a trial. And so in Virginia, those trials are on an expedited docket. In Fairfax County, they're often heard the very next week. Somebody says, nope, I disagree. I don't owe $5,000 in rent, and I'm allowed to stay there. The judge will say, fine, we're going to have a trial next Friday. In Arlington, the trials are not held the very next week, but it's usually within a couple weeks. So it just depends on how backed up the court is. Sometimes it's 2 or 3 weeks, sometimes it's a month or more. So that would be when you have the actual trial. And then if you win at trial, that's where you get your judgment. And then the next step is getting that writ of possession if the tenant still hasn't left. If you get a judgment against somebody, they are allowed to redeem the judgment one time and stay in the property if there's still time left on the lease. So one time in a year. So that means you've gotten a judgment against somebody that awards you, the landlord, $5,000 in rent and possession of the property. You wait 10 days for the appeal period. Nobody does anything. So you send in the writ to the sheriff. The sheriff processes the writ and schedules the eviction date. And that's where the sheriff comes back and supervises the lock change. And by the way, you have to pay for the locksmith. The sheriff is just there to keep the peace. The sheriff is not going to haul all the junk out for you. The sheriff is only going to supervise you changing the locks and watching the people exit the property. But the tenant has the right under the law one time in any given year to redeem the debt, which means to pay the $5,000 and the court costs and whatever else the judge awarded in the way of money and stay in the property if they pay that up to 2 days before the eviction happens. So just be aware, that's a real new change actually to the law. They used to have only a few days to redeem after the first return hearing. Now it's right up until the eviction happens, 2 days before the eviction. So you could spend a lot of money and time on thinking that you've gotten rid of this tenant and all of a sudden they pay and stay. So that's just one of the risks of being a landlord. And this class is not necessarily to scare you off on being a landlord. It's just to make sure you know the realities of how long things take to happen if you go the route of enforcing your remedies through the legal system, and to know how many laws are out there that protect you and the tenants. So that's it for my presentation. I think I've got time for more questions. So if anybody has any more questions, feel free to ask.
Okay, thank you for that. We have a few questions. I'm going to read the first group is from one person in regards to discrimination. It's how does someone prove discrimination? What if you meet one person and they give you bad vibes, or you have multiple other applications to choice and that upsets someone?
Well, that's a good question, because that is the point. They have to prove the discrimination. So let's say you do have 10 applicants for a given property, and in a hot market that can happen. So what you have to do is be very careful you don't say anything that indicates you're discriminating against them. If you get phone calls inquiring about the property, be aware that there are people out there who screen ads, and they will call, or they will have multiple people call with different voices or different accents and ask about the same property. And they're keeping records of what you say. And this is random. It doesn't happen to everybody, but if somebody suspects that you're discriminating against them because of their accent, they can make a claim to the local housing authority and say, I think, I had a friend of mine call and they said the place was still available, but when I talked to them, they said it wasn't. And so that agency has employees that will try and document what you say in response to people in inquiry about the availability of the property. So you have to be careful that you're consistent in your actions. You have to be careful that your ads don't say anything discriminatory. And that can include things like saying, it's obviously discriminatory if you say no kids allowed. Okay. And unless it's a property that's been designated as 55 and up only, you can't discriminate against children in a property. And you can say if you say things in your ads like not suitable for children, or no playground, things like that can add up to inferences that you are trying to discriminate. So you have to you have to know what the fair housing protected classes are, know what the laws are, and be very careful in how you word things. Have the fair housing logo at the bottom of your application, just to let people know what fair housing means. If you use a realtor, they know what the fair housing laws are, and so they're going to be watching out for your interests. But for a tenant to prove, or for an applicant to prove that you were discriminating against them, it's really hard. And I've only represented landlords in 2 or 3 cases where discrimination was alleged, and the tenant didn't win in any of those cases because they couldn't prove it, because there were plausible explanations for everything that the landlord said that wasn't a discriminatory reading of the situation. So that, for example, this person says they discriminated against me because I'm whatever religion, I don't remember, and because I come from whatever country. And so the landlord's response when they got that big questionnaire and the list of all the allegations is, I had no idea where this person came from. I never asked about their religion. You know, often it can just be the tenant making assumptions that they were discriminated against. And so they have to prove it. There has to be some evidence. And if they have none, they're not going to win, but it's going to cost you a lot of money defending it. So be very careful, because discrimination allegations can be very expensive to respond to. And it's hard to prove. You may win in the end, but you may spend, several $1,000s. So just be careful. And like I said, my general rule is don't be a jerk. If you're a jerk, it's going to come back to haunt you.
Yeah.
So,
we have a different question now. How to run a background check besides via the court website as an individual?
Well, there's services out there that will run credit checks on people. I think my office manager might have the name of one of them, because she was a landlord within the last couple of years. But you can just look online and read the reviews. The charge is usually about $50, and they will run a general background check and credit check. What you want is the credit check more than anything.
Okay.
You can for free. You can look on the sex offender registry for any person's name, the state. That's all a public record. So that's another way to do it.
Yeah. Regarding credit checks, is there any problems using Zillow?
I don't know if Zillow. I've never heard that Zillow offers credit checks. Maybe they do. If that's a service, I have no information about whether it's a problem or not.
Okay.
That would make sense to me that they offer credit check services now. That makes sense, because they're advertising properties all the time as available for sale or lease. So that may be a new service they're getting into.
Okay, thank you for that. Another question we have is, what is the safe reason to state in telling an applicant why you are not offering them a lease?
Well, you don't have to give a reason. That's the thing. The best, they're going to want a reason. If somebody else got there first, and that's the reason, then you're free to say that. It's not available anymore. Somebody was already rented to somebody else. But if the reason is financial, like you're just not financially qualified for this because you have a credit score of 200 and 3 prior evictions, and you've got prior judgments on your record from credit card companies or whatever, that's an easy one to give, and that's not going to be discriminatory. Although, like I said, remember the law has changed a little bit for evictions during COVID. So I've got to look up that statute. It goes into effect July 1st. So if they have a prior eviction on their record and it was during COVID, you do want to be careful about saying no because of a COVID eviction, during a COVID-related eviction for non-payment of rent. So I will look up that statute and send it to whoever asks. Okay.
Okay. Another question we have is
just email me. The email address is right there.
Okay, I'm pretty sure they will do that. Now, another question we have on our chat is, we are wanting to provide subsidized rent to first responders, teachers, etc. Will this be considered discrimination against other applicants?
Wow, that's a great question. So you're going to charge by subsidizing. You don't mean you're going to kick in a portion. You're just offering them a lower rent. I don't know the answer to that. It's okay. But I'm thinking it through. It could be. Let's look at those protected classes again. Let me find that. Sorry. Okay, so it doesn't say anything about employment status, where you work. So I don't think it's going to be a problem. And it's not a protected class under federal law or state law um, to discriminate based on the type of job you have. But there's a I'm gonna bring this up. There's a seminar coming up that I'm gonna attend on fair housing law in June. So if you want to, whoever asked that question, if you want to email that question to me, I'll know more about it after I attend the new seminar in June. But I also will probably do some research into that just because I'm curious about it. So send me an email and I'll respond to you privately.
Okay, I'm pretty sure they will do that.
Okay.
And I have another question. It says that, can you prohibit the smoking both inside and outside the property, like on a
Yes.
patio or a balcony?
Yes, and you can. So think about it. Smoking is a legal activity. You're allowed to smoke in Virginia. You're allowed to buy cigarettes. But you as a landlord don't have to allow smoking in your property. And there's a lot of reasons why, because if you're in a building with other people, smoke always gets under doors and goes through vents and disturbs other neighbors. Smoking also causes a lot of damage because it gets in paint and carpet, and the smell is very hard to get rid of. Often remediation after heavy smoking involves removing drywall and hardwood flooring and everything. You can't just cover it up with new carpet and new paint. So yes, you are allowed to prohibit smoking. And if somebody's smoking in a property where smoking is not allowed, the HOA, if it's a condo, the HOA is going to have problems with it too. So you may end up where you're getting the notices from the HOA saying somebody in the property you're renting is violating our HOA rules. This is a non-smoking building. So you're going to have to respond pretty quickly to avoid penalties from your HOA. And you're going to do that by sending a breach of lease letter to your tenants. So make clear, if you're not allowing smoking, make it very clear in the lease, all caps, bold, this is a non-smoking property, and make it clear to them that it's just not going to be tolerated. Now, that brings up another question I forgot to mention, the change in marijuana law in Virginia. Marijuana now has been decriminalized. So you can't, we used to get a lot of requests to send somebody a letter because they were smoking pot in the process, in the premises. And other neighbors were complaining or smelling it coming out from under their door, or maybe the property manager knocked on the door and, was assaulted by the smell of it. And that would have been a pretty typical violation of a lease for criminal activity. But now that it's been decriminalized, Virginia residents are going to be allowed, starting July 1st, to possess up to 1 ounce of marijuana and to grow up to 4 plants. So this makes smoking marijuana now, is this really going to be an activity that you can bar as a criminal violation of the lease? And the answer is no, I don't think so. But if you have a really strict policy in your lease that says no smoking of any kind, then you could send them a lease violation letter because they're smoking pot, not because it's a criminal activity, but because they're smoking. Because smoking causes the same, no matter what you're smoking, it causes the same annoyance to neighbors. It could be tobacco in the form of cigarettes. It could be tobacco in the form of pipes or cigars, which most people think are even more obnoxious than cigarettes. Or it could be smoking in the form of marijuana. And since there's other ways for somebody who wants to enjoy marijuana by taking gummies or other edibles, it's perfectly reasonable as a landlord for you to prohibit smoking of any substances. And you can include no burning of incense, because that usually disturbs neighbors too. So that's just something I want to bring to your attention, that and also marijuana smoking, marijuana possession of up to an ounce is going to be legal in Virginia, but it's still a federal violation of law. So we're in this gray area as states move to legalizing marijuana. I'm originally from Michigan, where now recreational marijuana is allowed to be sold too. So there's dispensaries popping up all over the place. Virginia is getting there, but that probably won't come until maybe 2023 or 2024. So right now you're going to be allowed to possess up to an ounce of marijuana and to possess up to 4 plants, but you can't buy seeds legally, and you can't go to a dispensary and buy pot legally in Virginia. So it's just going to be smoking and personal use and possession. So yeah, I would say definitely if you don't want any smoking of cigarettes, you probably don't want smoking of pot for the same reason, just because it's going to cause damage to fabrics, paint, carpets, annoying neighbors. And if somebody's going to be also growing pot in your house, they're 4 plants, whatever they're going to be legally allowed to possess, you can state in your lease that you're not allowing any growing of marijuana, because the thing is, marijuana needs a lot more. It needs higher temperatures. It needs a lot more utilities in the way of heat lamps and lights. And if you're the one paying the utilities, you don't want to get stuck with their, growing light bills. So that kind of thing, those are reasonable violations, reasonable things that you can prohibit in a lease. Sorry, such a long answer to a short question, but
it's okay.
yes, you can bar smoking.
Another question we have is, in your experience, if things go smoothly, but all remedies are used by the tenant, how long does it take to get a tenant out?
The fastest we can ever get somebody out is about 6 weeks. And that would be a case where we file, I'm going to use non-payment of rent as the reason for the violation. That would be a case where you've given them the notice that they have not paid the rent, and we file the next day after the notice period runs. So it used to be a 5-day notice to pay the rent, or you're going to face eviction. Now it's a 14-day notice, but as soon as you file that, give them that notice, we have to wait 14 days. If we file suit right away and we get a hearing within 21 days and they don't show up, then we can usually get that writ served within about 2 weeks later. So, 4 to 6 weeks, never 4 weeks, but 6 weeks if it's uncontested and everything goes smoothly. It's always going to be slower on the holidays. None of the sheriffs are in a hurry to serve people with eviction notices right before Christmas or Thanksgiving or in the middle, the dead of winter in a cold snap. So just be aware that they will be dragging their feet. And honestly, rightly so. They're going to be dragging their feet in the worst times of the year to put people out on the street. So that's where the don't be a jerk comes in again. Just keep in mind, these are human beings that you're putting out. So if there's a way to work with them, but protect your rights by knowing what they are and making sure that they know what their responsibilities are. And don't be slack in giving notices that there's a violation, and don't be slack in enforcing. You can always give people more time, but if you just let a non-payment issue go on and on and on, I've had people call me and say, the parents were alcoholics. I felt bad for the kids. They lost their jobs. One thing or another, this guy owned the home outright, and the tenants just weren't paying rent. And eventually the parents died, and the adult daughter was still there. And he let her live there for like 5 or 6 years. And she owed about $120,000 in rent. And she had a job, and she had a boyfriend who was living there, but he just wasn't enforcing the lease at all. And so I'm hoping none of you are going to be like that. This was a guy who could afford to do it, but then when he decided enough was enough, it was kind of late. There's no way you're ever going to collect all the back rent that somebody owes if you as the landlord has been slack on enforcing the lease. So that's all I want to say about that.
Okay, thank you for your answers. All the other questions we had were related to or discussed before. So we're going to go now with George, that will give us the go away and generate
Okay.
information. Thank you for your support.
Okay.
Thank
Thank
you.
you. And if anybody has any other questions, just send me an email and I'll try and answer.
Yes, thank you so much. And I want to remind everybody that uh, in Arlington County, we have 13 protected classes. One more is marital status. That's only in Arlington. I'm not sure if it's in Alexandria and Fairfax. And
What is
also
it? I didn't.
marital status.
Medical status.
No,
Okay.
marital.
Marital status. Oh,
Yeah.
yeah. Well, that would be under familial status. It's whether what
Uh,
type of family. You can't discriminate against people because they're just living together.
yeah.
Um,
Well,
or a parent with kids, doesn't have two. It's not a two parent family. So that yes, marital status would be under familial status.
Well, in Arlington County is considered one more, so that's
Okay.
why we have 13. The other thing that I want to tell everybody here is that if you want to take a 2-hour class of fair housing that we recorded last month, please go to the arlingtonlife.org. I post that in the chat, and our good friend Molly from DPOR, probably everybody knows Molly.
Yeah, that's the class I referred to on June 14th.
Yeah, she give a good presentation there for the fair housing month. The other thing I want to tell everybody, if you are a landlord, small landlord and have properties, yes, usually when you go, like Martha said, at the time of getting the tenant to pay and you know that they're not going to pay, try to get for the maximum on the judgment lien. So later on, you can sell that to a collection agent. They might give you between 20 and 50 cents on a dollar,
Mhm.
depending on the case. And that's the route to get at least a little bit of money. Otherwise, you're not going to get money
Another
back.
another thing, and I hate to interrupt you, but you just reminded me of something. If you get a judgment against somebody for several months of unpaid rent and property damage, you can record that judgment if they ever buy a
Yeah.
house. And we do have a lot of tenants who they violate leases by leaving early, and the landlords get judgments against them. And when we find out that they've just moved because they bought a house, we can record the judgment against them. And if they ever go to sell the house, the landlord gets paid. So
Yep.
that's a nice thing to know.
Yep, all of those. There are little tricks of the trade, especially
Yeah.
when you work in property management. There is a lot of little things that you learn. But Martha and everyone, thank you so much. This has been a wonderful class. We're gonna post the recording of this class in our webpage starting Monday. So anybody wanna do a refreshment? I don't know if you wanna share, Martha, your slides with everybody. If you can send that us, we can put it next to your video.
I can put that as a PDF if they want to just print
Yes,
out the
that'll
slides.
be great. That'll be
Okay.
great. All right. Thank you, everyone. Thank you, Martha.
Good luck,
And
everybody, being landlords.
be a good landlord. That's the name
Be
of
a
the
good
game.
landlord, but be a
All
smart
right.
landlord.
All right. Thank you. Thank you, everybody. Thank you so much, Hector. Thank you so much, Renee, and everybody. Tomorrow is another day. We have 5 more wonderful workshops. Bye bye.